little bit about Zach. He got started on this project because he is a volunteer with the Memorializing the Enslaved in Arlington project that the Arlington Historical Society, partners with the Black Heritage Museum of Arlington to research and find all the people who would never have been noticed, who have been sometimes lost to history. And we found, what, 1,400 people who, more? 2,700 people who did not have a place in history until now. So Zach researched this lawsuit brought on by a enslaved woman, and you will hear how it went not viral, but to the top of the legal establishment, and I'll let him tell you all that. But let me tell you a little bit about him. Besides being a volunteer with the Memorializing the Enslaved, he is a voting rights and election attorney whose interest in local history began after he and his wife bought an early 1900s farmhouse. He currently serves as the Yorktown Civic Association president, and he's on the board of the Langston Boulevard Alliance. His article about Julia Roberts' freedom suit is for sale in that Arlington Historical magazine. So if you want to read all the details that he might leave a few out, you are certainly welcome to purchase one. So all the money goes towards MEA and to the Arlington Historical Society. So with that, I give you Zach.
Thank you so much. Well, thank you so much. Can everyone hear me okay with the mic? Okay. And I guess on Zoom land, hopefully folks can hear me. We tested this out earlier, but hopefully people can hear me. But if not, speak up. I actually can't see you by face, but let me know otherwise. But anyhow, good evening. It is so great to be here and to see some familiar faces and some new faces as well. I don't come to these talks as often as I would like, because usually at this hour, my wife and I are in the thick of doing bedtime for our children. But today's a bit special because the kids are here past their bedtime. Because when you're 6, 3, and 8 months or 8 months old, where else would you rather be than listening to a lecture from your father on a 19th century legal history topic? And so to that end, I've selfishly packed in 90 straight minutes of dry legal analysis to help us get them in the right mindset when we do get out of here. In all seriousness, though, I admit that this is a talk about a very old lawsuit, that I am a lawyer by training, and so there might be times when it does veer a little bit into legalese or legal jargon. If that's the case, please feel free to yawn really obviously, and I'll do my best to be a little more engaging and also stop periodically to see if there are any questions from the audience, and I'll try to answer. But what's been really humbling while researching this topic is just knowing or realizing how much I and we don't know and probably never will know, unfortunately. But before I begin, just some quick acknowledgements. This is a really fascinating topic. I cannot take credit for finding on my own. I originally learned about memorializing the enslaved from Sue Eisenfeld's article in Arlington Magazine, and I was enthralled. Long story short, I reached out, connected with Jessica Kaplan, and she relayed this lawsuit's background and voluntold me to look into it. At first, I was a little apprehensive, a little overwhelmed with the amount of cursive writing, which, as historians know, is nowadays less a handwriting style and more a security system designed to keep modern researchers out. But once you're in the documents, and any historian here can really can attest to this, once you're in the documents, you're in it. And this really reopened my eyes to legal history and history generally after stepping away from it for several years. So thank you, Jessica, for not only everything that you do for AHS and memorializing the enslaved, and also for bringing me into the fold. And thank you to the Benbows as well for organizing this and so many other events. I mean, that is just the flyer that's out, I think, is just for the month of April and May. There's so much to look forward to. So tonight, we're going to follow a trail of paper, deeds, depositions, and runaway ads that span 60 years and several jurisdictions. We'll start with the intentions of an aging Revolutionary War veteran, look at the unintentional mistake that nearly cost a woman her liberty, but cost many others theirs. And finally, we'll focus on the life of a woman named Julia Roberts. As an aside, I do not know how she obtained her surname, but don't let a more famous, lighthearted last name distract from the ordeals that our Julia suffered through. Julia was a woman whose very body was treated as a legal battleground between the promise of a deed and the reality of the auction block. So our story begins long before she was born. It begins really with a man named Simon Summers. Summers was a wealthy landowner in Northern Virginia who owned several enslaved people and hundreds of acres spanning present-day Arlington and Fairfax counties. He was born in 1747 and was a surveyor by trade. That is, he helped identify and determine boundaries for property, a critically important task during this era. George Washington was also a surveyor among his many other jobs. During the American Revolution, Summers served as an officer in the 6th Virginia Regiment and 2nd Virginia Regiment, joining in 1776 and retiring in 1781 with a full pension. In his 1836 obituary, published after he died at the age of 89, he was described as an ardent and active friend of liberty who early on imbibed those patriotic principles which he cherished to his death. After the war, he retired to the peaceful pursuits of agriculture and has lived in this neighborhood ever since, universally esteemed. The blameless life and character of this excellent citizen caused those who knew him to love him, whilst his venerable appearance made him an object of general attention and respect. In all relations of life, he sustained an exalted reputation and has left to his descendants the rich legacy of his good name. And here we see his grave, which is located in, you can still visit it in Falls Church at the cemetery right downtown. And then to the right, I include a map that roughly shows where his house was. The exact location of his house is not precisely known. I don't think we'll ever know, but we can sort of get a rough approximation. Jessica and I have gone back and forth on this a little bit, but I think it's roughly a little bit southwest, perhaps, of Langston Boulevard and North Harrison Street, maybe give or take where the Rivendell School is. And I base that off of property disputes between his descendants after he died. But one thing that's important for our purposes is that he definitely lived in modern day Arlington County. So Summers was active in the early Methodist Church in Virginia, attending its general conferences in 1796 and 1800. This is a bit beyond our story, but he was referenced in conference notes and diaries and letters from early Methodist preachers who rode circuit in Virginia. And Methodists here and at this time were, as an organization, firmly against slavery. In 1800, for example, the General Conference of the Methodist congregation issued a pastoral letter on slavery signed by 3 church leaders who declared that enslavement of Black people is, quote, the great national evil of the United States, and urged state legislatures at the time to advocate for abolition. And I say all this just to provide some context for Summers and his apparently complicated relationship with slavery. Through the course of his life, he did enslave quite a few people. For example, on May 16th, 1785, in exchange for 90 pounds specie, Summers purchased, quote, 1 Negro woman named Frank and a child named Sarah. In 1801, he enslaved at least 5, probably more, and by 1820, according to the census, there were 5 male and 7 female people enslaved people living on his property of various ages. But around the turn of the 19th century, he was on an anti-slavery kick, perhaps due to the direct influence of the Methodist General Conferences that he attended. On December 31st, 1801, he drafted a deed of emancipation that set free 5 enslaved people he could claim title to: Millie, Fanny, Sarah, Will, and Hannah. The deed also specified the descendants of these enslaved people who would be free at the age of 25, and any of their children, the named enslaved people's grandchildren, would be free at the age of 21 years. Why free them? He says so in the deed, because slavery is, quote, contrary to the spirit of Christianity or humanity. These were not immediate emancipations, of course. In fact, none of the named enslaved people would be free until many years from the date of the deed. Relevant here, Sarah, who was around 18 in 1801, would not be emancipated until January 1st, 1814, an excruciating 13-year wait. And As for Sarah's daughter named in the deed, the 5-month-old Hannah, her emancipation date under the deed's terms was not until January 1st, 1829, almost 3 decades from then. Some of Simon Summers' human property, did not wait. Newspapers during the era are filled with ads for runaways, quote, runaways from enslavers, offering rewards or information for men, women, and children who left enslavement on their own terms. This included a young man and woman from Summers' property named Dennis and Hannah, different Hannah, who were the subject of a runaway ad from Summers in 1806. The ad includes physical descriptions of the young man and woman, and note the language in this ad that almost complains at the very end, I set both their mothers free and did intend to set them free if they had behaved as all servants ought to do. He continued, I forewarn all persons from harboring, employing, or conveying them away. Turning back to the deed, Summers had drafted it on the last day of 1801. On January 18th, 1802, he traveled to the courthouse in Fairfax, Virginia to record it, that is, make it official in the eyes of the law. For Summers, making the 10-mile trek to Fairfax from his home in present-day Arlington was almost certainly a routine errand. At this point, he was in his 50s, he was employed as a surveyor, he was probably used to traveling through the area, including to the county courthouse for business. He was also a farmer and probably spent quite a bit of time selling crops or managing the selling of crops in town. As one historian put it, the courthouse supervised almost every aspect of life in the county. It was, quote, the social, commercial, and political center of the county, end quote, the town hall, coffee shop, Facebook, and next door rolled into one building. But there was a twist. Summers had been used to going to Fairfax for business for years. This was, after all, because it was the county seat of Fairfax County, and he'd spent almost his whole life up until that point in Fairfax County, outside of his military service. But the new federal District of Columbia had just been created, and the boundary went right through his land. His house lay to the east of that border. The boundary, as many of you know, is the present-day border between Arlington and Fairfax counties, but back then, this border was the border between the new District of Columbia and Fairfax County. It would not be until retrocession in the 1840s that this reverted to become then Alexandria County, and this border became operative on February 27th, 1801, less than a year before he recorded the deed. So Summers' decision in 1802, January 1802, to travel to Fairfax, even to undertake a really mundane bureaucratic procedure that he'd been doing probably for years, meant he was traveling out of his home jurisdiction and into Virginia. Who cares? Did this matter? It did. It really, really did. And I'm afraid I'll revert slightly to legal jargon. Virginia law allowed for emancipating slaves, but only under certain regulatory conditions that the legislature codified in the 1770s. An enslaver could free an enslaved person in a deed, and I'll quote from the law here, under his or her hand and seal, attested and proved in the county or corporation court by 2 witnesses, or acknowledged by a party in the court of the county where he or she resides. But the Virginia law no longer neatly applied to Summers quite so neatly because he did not live in Virginia. Summers was now a resident as of February 27th, 1801. He was now a resident of the District of Columbia. And there was a further quirk, just to really complicate things, there was a further quirk under the federal law that created Washington, D.C. Virginia law applied to district residents on the Potomac River's west side, southwest side, while Maryland law applied to district residents on the Potomac's east side, which include Washington and Georgetown. So even though Virginia law still governed him, Summers had to record the deed in the, quote, court of the county where he resides. And this was no longer Fairfax County. Instead, the change in jurisdiction meant Summers had to go to a county courthouse on the Virginia side of the district. This was in Alexandria. So where he recorded the deed did matter quite a bit. And at stake was not just the very validity of the deed, but also the difference between freedom and slavery for the enslaved people named in it and generations of their descendants. And also, I'm not exaggerating, this move that he did to go to Fairfax to record this deed would echo through generations of people for the next 60 years. Only the Civil War and the official emancipation of all enslaved people with the 13th Amendment would cleanly end this dispute. So that set the scene. I'll now turn to Julia's story, Julia and Sarah. I made a very rough family tree here, but there are a ton more people in these families and lots of interconnections between some names that local history experts here will recognize, like the Ball family and the Minor family. But yeah, this is a really simplified family tree. So again, Simon Summers purchased Sarah in 1785 when she was just a child. Assuming she was 18 when the deed was written in 1801, as it said, Sarah was probably just about 2 when she was sold to Summers. She grew up at the Summers property. In the late 1790s, around 1797 or 1798, Summers gifted her to his daughter, Anne Nancy Summers, and his new son-in-law, Wesley Adams, as a wedding gift. And quoting from some documents, Summers gave the newlyweds, quote, 2 Negroes, one the best, the other the worst he owned. One named Sarah, which he deemed the best, the other William, whom he supposed the worst, being afflicted with what is called white swelling, end quote. And just, I was curious what white swelling was, and that was a 19th century term, looking at contemporaneous medical treatises for a bacterial bone infection that involves swelling, stiffness, and fluid accumulation in the joints. And so for individuals who were forced to do physical labor, just not a great ailment to have. And the quote that I just read, that was from a later deposition from George Minor. So even though William and Sarah were gifts, their enslavement had expiration dates for the newlyweds because of Simon Summers' deed of emancipation. As an aside, after Summers died, his estate's division went through a sort of probate process and involved accounting and dividing up various property, including enslaved people, among his heirs, and that accounted for also the monetary value of William and Sarah. And that value was modified downwards, which reflected their emancipated status. In other words, the shortened period that these people were able to benefit from their uncompensated labor. And so the two were, quote, considered as manumitted slaves, and their values estimated accordingly, end quote. So enslaved people with distant emancipation dates could still bring quite a bit of financial gain to the Adams family through labor, and more significantly, their descendants. Sarah had a good many children, recalled Austin Adams, one of Wesley and Anne's sons. Another one of Wesley and Anne's kids recalled Sarah had 14 children. Among them was Julia, apparently born on April 23rd, 1812, at least according to testimony from Wesley Adams years later. The precise birth date was an issue in Julia's later freedom suit. If she was born after Sarah's manumission date, then she would have been born free under the long-time doctrine in Latin, partus sequitur ventrum, the status follows the woman, which basically says that a child's legal status follows that of his or her mother's at the time of birth. For Wesley Adams, however, some of Sarah's young children provided income through being sold as slaves for a term of years. These were enslaved people who other slave owners purchased to labor for them for a certain period of time specified in a written or oral contract, a form of renting a person, if you will. So in 1818, Wesley Adams sold at least 3 of Sarah's daughters, Charity, Hannah, and Julia, for terms of years at a sale on his property. This is an advertisement in the Alexandria Gazette, which noticed a public sale at 12 o'clock on April 15th, 1818. And I could have quoted just the sale, but I thought I would include everything else just to show just the diversity of things, I guess, that were for sale, goods and services. If you wanted rice or lemons, if you needed a farmer, a gardener, or a person, all of this was available for sale or rent in the Alexandria Gazette. A Fairfax County farmer named George Crump purchased Julia for either $45 or $50, depending on later conflicting testimony, and she was as young as 5 years old, no more than 6 years old. Wesley Adams recalled that she was 5 when she left his farm in a later deposition. The scene was almost certainly one of unimaginable heartbreak and fear. Julia was separated from her home, her siblings, other family members, and likely friends. Despite this awful terror, there was a distant, very distant glimmer of hope, that deed of emancipation. As Sarah's child, Julia was to be free when she was 25, under the deed's language. Wesley Adams even gave Crump a bill of sale, specifying the time of her servitude, quote, which was for 20 years from the day of sale. And Julia could also look to her mother as an example of someone who was actually emancipated under the terms of the deed. Her ending does not appear to be one of extreme happiness, as far as I can tell, but Sarah did live the rest of her life as a free woman. In 1820, a semi-governmental body called the Fairfax County Overseers of the Poor sued Simon Summers for the, quote, support and maintenance of a Negro Sarah, a free black emancipated by Summers, who it is stated was of unsound mind and body at the time of her said emancipation, end quote. What that means is reality is hard to know. This was just a short entry in a log of cases that appears in the court's minutes books, but long story short, it meant that Sarah was free, at least as of 1820. So from around the age of 6 onwards, Julia lived at the Crump family farm in Fairfax County. Where was this exactly? I haven't been able to tell precisely. Fairfax County does have a pretty detailed 1860 land ownership map that's available online, and I can find some land owned by George Crump's widow, Jane. This is centered a little bit west of Lincolnia near Turkey Cock Run in Little River Turnpike and Duke Street. There's a Hobby Lobby over there. When Crump died in 1847, he left 20 acres to Jane Crump, but the 1860 map shows quite a bit less. So it's possible that she sold some of the land to maintain herself, but it's fair to say that Julia did spend most of her youth, actually most of her youth in Fairfax County. Julia's day-to-day life was undoubtedly difficult. Enslavers often required women to work in the fields, which of course included physically demanding work like clearing and preparing land, growing, harvesting, and preparing crops like wheat, barley, corn, raising livestock, caring for any vegetable gardens or orchards on the property. To quote a historian, Brenda Stevenson, their work was hard and often monotonous, their workdays long, and their punishments cruel. As Crump's sole enslaved property, Julia probably split her time between work in the fields and time spent as a domestic servant. In the latter role, her tasks may have covered everything from cleaning to gardening, butchering, cooking, serving meals, sewing, carding, weaving, midwifery, and nursing. Crump had access to decades of her uncompensated labor for no more than $50, but he apparently complained to an acquaintance that, quote, Julia yielded him no profit, prompting the acquaintance to suggest selling her. Crump replied he couldn't do that because she was to be free when she attained the age of 25 years. Part of me wonders if this comment about her not yielding him any profit is a reference to the fact that, as far as I could tell from the record, she had no children. I don't know if the child of a term slave would go to the lessor or to the original enslaver, but it's something to grapple with as we can consider the day-to-day horrors of slavery and the potentially twisted motivations of enslavers. As we get toward the end of the 1830s, after years on the Crump farm, Julia probably was starting to yearn for the freedom that her mother had. She almost certainly knew about her promised freedom and had for years. She probably was counting down the years, the months, the weeks, the days. Julia wasn't the only one who knew. One of Crump's neighbors in later testimony said about her freedom, quote, the impression was so universal that the sale was until she became 25 years of age that the question was never raised by anyone. And just a quick note on sources, I keep quoting these things and I really lucked out because Wesley Adams happened to move to Florida, and somehow because of this, a bunch of documents of his from a lawsuit between him and George Crump exist. Most of pre-Civil War documents in the Fairfax County Courthouse Historic Records Center are scattered because of war-related damage or outright destroyed, and it's just a stroke of luck of historical research. That's just the thrill of the chase in a way. But a bunch of valuable testimony exists in this case, Crump versus Adams. In that case, it was basically about which party could claim ownership over Julia. In January 1839, and Julia would have been roughly 27 years old, so she was entitled to her freedom under the deed terms at this point. George Crump apparently delivered to Austin Adams to be safely kept by him and to be re-delivered to Crump. Why he delivered Julia to Austin is not clear, but Austin apparently declined to return her. Crump filed an action for detenue, a type of legal action to recover property that is allegedly detained wrongfully. Interestingly, all of the surviving testimony in this case, Crump versus Adams, are from witnesses who support Austin Adams' position that Crump had no claim over Julia because she was supposed to be free after the term of years. The witnesses include Wesley Adams and his brother John. I thought it might be interesting, hopefully, just to quote directly from some of this testimony. So first, a deposition from a witness named John Wood. Question, are you acquainted with the plaintiff and defendant in this case? Yes. Question, have you ever had any conversation with the plaintiff concerning a Negro girl named Julia? If yes, state it and when that conversation took place. Answer, about 3 years ago, the plaintiff remarked to me that Julia yielded him no profit. I then observed to him he ought to sell her. Plaintiff, who again is George Crump, then said he could not do that because she was to be free when she attains the age of 25 years. Have you any interest? Question, have you any interest in the resolution of this cause? Answer, no. Second, I'll read from the deposition of Wesley Adams' brother named John Adams. Question, state what you know in respect to the terms upon which your brother Wesley Adams sold the Negroes which he held under the will of Simon Summers, and in particular the terms of the contract made with George Crump for the Negro woman sold by your said brother to said Crump, and what you might have heard your brother say on this subject. Answer, my brother stated to me that he sold the Negro Julia to George Crump for a term of years, either until she was 25 or 28, and I think after this, George Crump stated to me that she would be free at the expiration of that term. My brother also stated that he had sold the other Negroes upon the same terms to Mr. James Whaley, who stated to me he bought off my brother a Negro girl of the same family for a term of years and asked me what would be done with her when the time expired. I don't know if you caught the reference to a man named James Whaley, but just remember that name for later on, just a little bit of foreshadowing. So long story short, on the Crump versus Adams case, that case ended in October 1839 when a jury found for Adams. The details of the verdict are a little sketchy, but Adams argued that he did not detain the slave. Instead, Julia was with his sister, whose name was Anne Harding, another child of Wesley Adams and Ann Summers. This might have been enough of a technicality for a jury to find for Adams over Crump. The resolution of Crump versus Adams, in my view, is less significant than what happened during the case as it proceeded. On June 21st, 1839, in Jefferson County, Florida, where Wesley Adams now lived, he and another witness had sat for a deposition in the Crump case. The next day, Wesley Adams initiated a transaction to lay claim to Julia, despite Simon Summers' deed and Julia's entitlement to freedom. On June 22nd, he sold to his son Austin, quote, all my rights, title, and interest, which I now have or ever shall have, to a certain Negro girl who is a slave to me for life, named Julia, end quote. In exchange, Austin paid $5. The witnesses to this deed of sale and the two depositions in Crump versus Adams were the exact same people. One was a Florida justice of the peace, and the other was a merchant whose home was where the depositions took place. The bill of sale was then recorded in Fairfax County later that summer. I remember I took this photo at the Fairfax County Courthouse Historic Record Center, and I saw this deed, which is available in one of those giant old deed books, which has become loose paper now. And when I saw that language, I remember I gasped, a slave to me for life. It was staggering, considering what Wesley Adams had said in his deposition taken the day before. It was a betrayal of Simon Summers' deed of emancipation, of course, and conflicted with the idea that slavery was contrary to the spirit of Christianity or humanity, the language from his deed. And this betrayal had been done with the full power and trappings of the law. Wesley and Austin Adams used the law's authority to support their ownership over her, the bill of sale, supported by official witnesses and their seals, was received properly, quote, received properly, authenticated, and admitted to record in a court of law. And it was now legally recorded in Fairfax County that Wesley Adams' ownership of his so-called slave to me for life had passed to his son, Austin. More immediately for Julia, the sale closed any direct path to freedom. Under Summers' deed, she was supposed to have been acknowledged as a free woman when she turned 25, a date now long in the rearview mirror. By 1839, she was roughly 27. So to achieve freedom through anything other than escape, Julia would have to seek help from a legal system that largely denied legal capacity, legal standing, and access to law for a person held as a slave. And so I'll turn to the freedom suit in a second, but I wonder if there's any questions from the audience or from Zoom. Also an excuse for me to get a drink of water. Nah, that's fine.
No questions from Zoom at this point.
Okay, so many people are surprised. Oh, yes, hi. That's a great question. Oh, and I have to repeat the question. The question was, what was the big deal about waiting until your 20s to be emancipated? I don't have an answer off the top of my head, but I know a lot of scholarship has been done recently called The Rising Generation by Sarah Groningsater that focuses on these really long emancipation periods out of New York State in the late 18th century. I could probably speculate on why this is the case, but I think there was probably this really paternalistic view that if you free and you emancipate an enslaved person at the age of 5 or 6, they wouldn't know what to do, which is maybe true because they're 5 or 6. But it was also probably this really paternalistic view that they just we're not capable. Good question. Sorry to not have an answer off the top of my head. Okay, so turning to the freedom suit now, the reason we're all here. Many people are surprised to learn that enslaved people could sue for their freedom. And these are not easy endeavors. One thing I should note about these type of lawsuits is that the enslaved person turns plaintiff or petitioner had to have some sort of legal basis for their claim. This was not an appeal to humanity, an appeal to God, or some sort of violation of the US Constitution, which very much famously permitted slavery up until 1865. These were not appeals to ethics or morality. Rather, an enslaver had to be alleged to be violating a specific law in holding someone wrongfully as a slave. It was really a matter of contract or property law. And so how could an enslaver do this? Several methods, and these are just a few. A wrongfully enslaved person could allege that they were in fact free and illegally kidnapped, a not uncommon occurrence to modern audiences. This might sound familiar from 40 Years a Slave, a recent-ish movie that was based on true events of Solomon Northup, who was kidnapped. He was from upstate New York, and he was kidnapped. I think he was in Washington, D.C. He was. A wrongfully enslaved person could also allege that they were born of a free woman. A wrongfully enslaved person could allege that their enslaver for a term of years held on to them for longer than the term allowed. This would have maybe happened in Julia's case if George Crump continued to claim ownership over her, or a wrongfully enslaved person like Julia could claim that a deed of emancipation granted them their freedom. For any of these lawsuits, a petition is then filed in the relevant court. Because these enslaved people often had little to zero money, they would sue in forma pauperis. The court would assign the enslaved person counsel to represent them. A law passed in Virginia in 1795, and remember, Virginia law controlled, even though this was technically in Washington, D.C., allowed unjustly and illegally detained enslaved people to file freedom suits. And the venue for anyone filing in Arlington County would be the Circuit Court for the District of Columbia, a federal court that actually doesn't exist anymore after some 1890s era reforms. Today we have a district court and a circuit court of appeals, but for a time there was this intermediary level. The circuit court functioned as both a trial court and an appellate court, depending on the type of case. And for freedom suits in Washington, D.C., it functioned as the court of first impression. So after a petition is filed, a summons is then served on the enslaver, notifying them of this lawsuit. This would then require them to post some sort of bond to guarantee that the enslaved person is able to go through the legal process, appear at court, and generally be kept free from any punitive measures. I'll skip the history of the bond process, but basically it was a common law process that really started in the early 1840s after this federal court in DC held that an enslaved woman who had sued for her freedom couldn't be shipped off to a buyer down in South Carolina. The court forbid the buyer from taking this enslaved woman away to prevent the buyer from absconding with her, even though she had a pending claim for freedom. So after the summons is sent out, the discovery process follows. This is where each of the parties gather evidence to support their claims. Nowadays, litigators deal with fun piles of millions of documents, emails really through file transfer websites. But back then, discovery was really a few depositions and a handful of written documents like wills or manumission papers and other documents. And as a former litigator, that really sounds like a dream amount of discovery. And this is more or less how the process worked with Julia. At the time she filed her petition for freedom, she was living with Anne Harding, who was Austin Adams' sister, the child of Wesley and Ann Summers, and she was Simon Summers' granddaughter. I'll go back to Ann Elizabeth Harding at the bottom there. So much of this action that I've been talking about so far has taken place in Fairfax County, but thankfully this 1839-1840 transfer of Julia back to Ann Harding takes us back to Arlington County, and perhaps why I'm here tonight instead of with our friends across the border, a less illustrious group between us. So Harding had property that encompassed portions of today's Barcroft, Arlington Forest, and Buckingham neighborhoods. Fortunate for us, I guess, fortunate broadly defined, Julia was held as a slave at the time of the 1840 census. And so by sheer coincidence, we can verify that she was part of Harding's household at the time. And so later on, Harding's son would sell the property, initiating a chain of sales that ended with James T. Clark at the time of the Civil War, which allowed me to identify where this property was, thanks to the excellent work of the Historical Society in creating an 1860 map. And so this slide shows where this property was located in 1860. After the war, Clark's heirs put in a claim to a post-war commission for damage done to the property, and one witness described the house. And I'd like to think that this is the house that Julia lived in when she filed her petition for freedom. It was about 18 by 20 feet. I'll just quote from this, quote, about 18 by 20 feet, I suppose, and 2 stories high, with a back building 1 story high and the length of the main building, and built of frame and logs. In addition, the property had a smokehouse and granary, a stable, and such other buildings as are usual. And so these were the conditions that she lived in as Julia seethed under the conditions the Adams family had forced on her and grappled with how to resist. Julia's petition asserted that a certain Austin Adams claims your petitioner as his slave and does hold her in slavery by authorizing his sister, Mrs. Ann Harding, to keep your petitioner in slavery. Although she said that in the third person, that is the only time she ever really speaks in any document that I've been able to find. The court's minute book first referenced Julia's petition on October 13th, 1840, suggesting she filed the petition shortly before that. On that day, the court assigned 2 attorneys, William Brent and Robert J. Brent, a father-son duo, both well known on their own, to hear her case. They were tasked to examine and report the facts back to the court, and in an affidavit also filed that day on October 13th, 1840, the 2 attorneys wrote that they were satisfied that it could be proved that Summers executed a deed of manumission. And because of that deed, Sarah and her issue, including Julia, became free according to the terms of said instrument of manumission, and that the petitioner is now free. So, filing the freedom suit had immediate consequences for both Julia and her alleged enslavers. The court ordered that Julia be committed to the custody of the Marshal of the District of Columbia and detained by him until Austin Adams or Ann Harding entered into a bond in the penalty of $1,000. This sizable bond, the court explained, would ensure that Julia would be, quote, forthcoming at the trial of the suit for her freedom and to permit her to take steps to prepare for said trial to attend court. The defendants must have paid the bond because Julia and her attorneys were able to gather evidence. They took the testimony of several witnesses over the course of 1841. The case record contains summons of members of the prominent Minor and Ball families, among other individuals, to appear at the courthouse in Alexandria to testify on behalf of Julia Roberts or face steep penalty otherwise. The evidence that Julia presented at trial included testimony from several individuals. The overarching theme for Julia's evidence was that her mother, Sarah, was freed from the deed of emancipation, or I guess by the deed of emancipation, and it was now Julia's turn. So, for example, a witness named John Harrison explained that he knew Julia when she lived with Wesley Adams. He heard the elder Adams, quote, frequently speak of Sarah, the mother of the petitioner, as being free, end quote, and that Adams even offered to sell him Julia. He also understood Julia to be free under the deed of emancipation from Simon Summers when she arrived at a certain age. The most important piece of evidence of Julia, though, was a copy of the deed of emancipation. Its language was so very clear, and so the defendant's strategy was to cut it down. 2 witnesses, William and George Minor, focused on where Simon Summers' real property was, going back to my description of where he was earlier, where his house was earlier. Summers settled land, quote, is all in Alexandria County in the federal district, testified William Minor. While Summers had land in Fairfax County after the District of Columbia's creation, it was just forest, and Summers did not cultivate any land in Virginia after his removal to the county of Alexandria, end quote. In fact, recalled George Minor, the nearest part of his farm from the district line is about a mile. And so the evidence that the defendants put forth told a clear story. Regardless of Simon Summers' intent, he did not comply with the law's clear requirements by recording the deed in Fairfax County because Summers did not live in that county. As a result, the deed was invalid. And because, as the defendants claimed, Julia was born before her mother's manumission date, she wasn't born to a free woman, and therefore she could not be free. The trial lasted 2 days in May 1842. The judge overseeing this case, William Cranch, was a longtime jurist who was appointed by President John Adams in 1801. At no point in the trial did Julia speak. It was unsurprisingly a process for white men, even as she had the absolute most at stake. At the end of the trial, the defendants made some objections. All were focused on getting the deed out of evidence. First, they tried to exclude the copy of the deed from the record. The judge overruled this objection. Second, they tried to obtain specific instructions to the jury that the deed was invalid based on Summers' residence in Washington, D.C., when he recorded it in Fairfax. Again, Judge Cranch refused to give this limiting instruction because doing so would, quote, take the cause from the consideration of the jury without giving the petitioner the benefit of the presumption which the jury might draw from the facts so given in evidence, end quote. Put simply, the instructions that Adams and Harding wanted to give would have constrained the jury to only find for the defendants. So after declining those instructions, Judge Cranch ordered the jury to deliberate the freedom suit. And I'd like to pause here for a second and ask you to put yourselves in the jurors' deliberation room in 1842. You have a deed written by a Revolutionary War veteran who clearly intended for these people to be free, but you also have the strict letter of the law saying he filed it in the wrong place. If you follow the law to the letter, Julia stays enslaved. If you follow the spirit of the deed, she is no longer enslaved. So I'm curious, maybe we could close our eyes to make it, no peer pressure, but how many, I guess in the audience, because I can't see the Zoom folks, how many of you would vote for the petitioner Julia? And don't be shy, how many would vote for the defendants? Everyone's eyes are open, but it was unanimous. So we don't know for how many hours the 12 men deliberated. There was a fair bit of evidence to consider. There was testimony from at least 6 witnesses and the deed itself. When the jury returned, the foreman, Thomas Baird, handed a slip of paper to Judge Cranch or to court staff. Baird, a court official, or the judge then likely read the paper out loud. We of the jury find for the petitioner. Julia had prevailed. It's hard to even fathom the emotion that she felt at that point. But whatever feeling she had was fleeting because Austin Adams and Ann Harding appealed the verdict. The appellate court for the circuit court for the District of Columbia was the United States Supreme Court, so that's where the appeal landed. This appeal focused on 2 issues. The first issue focused on Judge Cranch's decision to allow the jury to even consider the deed. In Austin and Ann's view, the Virginia law on emancipation by deeds gave, quote, no such power to non-residents owning slaves in that state, end quote. Summers fell into that category based on his residence in the District of Columbia. The issue was, quote, of such extensive interest as to render the final decision of it by the Supreme Court desirable, the defendants urged. Adams and Harding's second objection was that the jury, even after considering all the evidence before it, should have been instructed that the total evidence is, quote, not sufficient in law to find for Julia. The Supreme Court did not buy these arguments. Justice James Wayne wrote for a unanimous court, a court that included some figures not especially friendly to enslaved people, to understate things, like Chief Justice Roger Taney, who would later write the Dred Scott versus Sanford decision. The essence of his decision, of Justice Wayne's decision, was that the jury is the finder of fact, and any constraints on that power should be rare. Justice Wayne first laid out how Virginia law allows for manumission via deed. He explained how the record was not precise on where exactly Simon Summers' house was or whether his slaves resided elsewhere, quote, detached from his residence, but it didn't really matter Justice Wayne wrote, because Summers had been accustomed to resort to the court of Fairfax County for the transaction of business of every description, and that the jurisdiction under which he lived then became changed without Summers doing anything, end quote. This reliance on Summers' custom was notable. It varied very much from Adams and Harding's view that a party would strictly follow a statute's requirements. Justice Wayne then recounted at length the evidence that the jury considered, the deed, the witnesses, and how the jury only had a copy of the deed. He laid these facts out to show how many factual questions were before the jury, and the jury instruction that Adams and Harding asked for would have excluded all other evidence and put the legal issue, quote, proposed on it upon a single fact. It excludes also all presumptions which the jury might take from the other evidence, end quote, about the deed's validity, like its age, that the version they saw was a copy, and whether the deed's witnesses were proper. The proposed instructions took too much fact-fighting discretion away from the jury, in other words, and it made the case's outcome dependent on a single fact, namely that the residence of Summers in the county of Alexandria and that Julia was not entitled to freedom. So overall, the jury had a lot of evidence before it. Adams and Harding's requested jury instructions would have transformed the jury's traditional role of fact finder into almost a rubber stamp. And the court's opinion stood for the proposition that it was a jury's duty to weigh all of the evidence properly before it, not the trial judge with any constraining instructions. Judge Cranch did not commit any errors when he refused the proposed jury instructions, the court held. So what did this mean for Julia? She was unmistakably a free woman. Her case was only one of 6 freedom suits originating in DC federal court that was successful in the US Supreme Court. And so following Virginia law, Julia had to register as a freed woman. She did this in Alexandria, and this is the only time her appearance exists in any known document that I've been able to find. Julia Roberts, a free woman and about 36, of dark complexion, 5 feet 5 and 3/4 inches high, with a slight scar on her nose, who obtained her freedom by the judgment of the said court at May term 1842, was registered in this office this 6th day of October, 1845. In the 1860 census, Julia Roberts, I don't know if this was the exact one, but a Julia Roberts appears as living in Georgetown. Her age, race, and occupation as servant seem to track with our Julia. And interestingly, not that far away, Anne Harding lived in a neighboring ward in Georgetown. And so this is where the article ends in the Arlington Historic Magazine. It's a happy ending for Julia, but with your indulgence, hopefully, I don't know how we're doing on time. With your indulgence, I'd like to spend just a couple more minutes on some additional aftermath that didn't make it into the article. And it's a less happy ending, unfortunately. So going back to the family tree, Sarah, as you recall, had many children in addition to Julia. One was a woman named Charity, who was sold at the same 1818 auction that saw George Crump purchase Julia for a term of years. Charity was sold to a Loudoun County resident, James Whaley, who you might recall me mentioning earlier. Charity herself had several children, including a son named Peter French and a daughter named Fanny Douglas. Charity passed away from cholera in 1832 before her term of years was up. But Peter and Fanny were entitled to their freedom under Simon Summers' deed as grandchildren of Sarah. As you recall, that generation of Sarah's descendants were to be free at the age of 21. Unsurprisingly, Peter and Fanny were not freed at the age of 21. James Whaley died at some point, and his heirs held on to Peter and Fanny as slaves. So Peter, Fanny, and Fanny's son sued in Loudoun County sometime in the fall of 1849 under an almost identical theory as Julia. But unlike Julia, they never received those magic words saying a jury reached a verdict in their favor. During a special term of the Circuit Court of Loudoun County in December 1851, I found evidence that a jury was sworn in a case, but they could not reach a verdict. And the case is then continued for the next 3 years when the parties consent to changing the venue to Fairfax County. And then I found a letter shortly before Christmas 1857 from an attorney seeking really quick relief because, quote, the slaves in question are advertised to be sold at an auction on December 26th. That attorney referenced how the petitioners were not successful in their lawsuits so far. And there I lose the thread on this particular case, but then another lawsuit from our old friend, enemy, Austin Adams appears. Adams had sued James Whaley's estate seeking an action for detenue. Remember that term, detenue? It's wrongfully detained property, allegedly. And the property in question were 11 enslaved men, women, and children who, Austin Adams alleged, were worth more than $15,000 in 1860 dollars, which is more than $600,000 today, according to an internet search I did. Adams' theory rests again on the invalidity of the Summers deed. Whaley's estate held on to Charity's descendants, who now numbered at least 11 people. Charity had been sold for a term of years to Whaley. Once that term was up, in Adams' view, ownership should have reverted back to the Adams family. Never mind Simon Summers' deed, and never mind Whaley holding on to the enslaved property. This case by Austin Adams was delayed, again, multiple times through the 1850s and was transferred to Fairfax County in April 1860. And here again, I unfortunately lose the thread, but I think it's worth, maybe I could take a look again in case anything happened between then and the outbreak of the war. I don't know exactly what happened to any of Charity's descendants because those were outside of Julia's precise narrative. I use those sources mostly to corroborate or examine Julia's story, but I think it's worth remembering what started all of this. Simon Summers recording his deed of emancipation in 1802 in Fairfax, Virginia, an illegal technicality that his descendants then weaponized for their own gain. So in conclusion, tonight, we remember Julia, not just because she won, but because she had the courage to sue, to step into a courtroom that wasn't for her, to face, that wasn't built for her, to face the family that had betrayed her, and to demand that, quote, the spirit of Christianity and humanity, end quote, promised in 1801 finally be honored. Thank you.
It's on.
Thank you. Wondering if you could reflect more on the fact that an all-white jury in pre-Civil War Virginia voted to give a woman who was enslaved her freedom.
That's a great question. Should I repeat it for the Zoom folks, or did they got it? Okay. Yeah, great question. There's actually a source called Oh Say Can You See, which examines freedom suits in Washington, D.C., which includes, at the time, Arlington, Alexandria, and parts of, actually their database goes back to Maryland as well. And they've run some data analytics that show actually a little bit more than half of these freedom suits were decided in favor of the petitioners. And it is interesting that these claims could not have been brought under theories of humanity or human rights or rights secured in the US Constitution. It was really more a property law, a contract law issue. And I think in a perverse sort of way that allowed an all-white jury to sort of come to that conclusion that this sort of system allows for manumission when somebody is wrongfully held as a slave. So yeah, I'd never really considered it up until now, but I think that sort of lens, by viewing these freedom suits as a property or contract law dispute, might make it a little more palatable maybe to some of these members of the jury. And I recall that using the memorializing the enslaved in Arlington database, that at least one of the jurors that was on Julia's jury was a slave owner. Last name Veitch. There's a street named after him. He was on the jury, or a member of that family was on the jury, and he was an enslaver.
I would assume that if I had been enslaved and I knew that I had a deed that said I should have been free by the 1830s and they held me for another 10 years, one of the things that I would sue for is that I should be paid for all of those years that I had to work for you for nothing. I'm sure that from everything you said that Julia never got any money for this. Do you know of any cases in which a person who had been enslaved was able to get money from the people who had improperly held them after it was shown that they should not have been doing so?
That's a great question. and I know exactly where, I think I know where to look, but I don't know off the top of my head. Among the cases that I looked at for this project, no one had that as part of their claim. It was really focused on their status. There wasn't a damages portion. The remedy was really like, get me out of here. But I don't know. I wonder if that was barred by statute. I can only speculate. I don't know. But that is a logical question that I should have looked at before. I'm sorry.
Any other questions here in the audience? Oh, we got one.
Did you find any evidence of what Julia did during all these years? Was she still working in the home of Ann Harding? Can you speak to that?
I can only speculate. Like, I don't even know where she lived during the pendency of this lawsuit, because she filed it in October 1840, and the verdict didn't come down until May 1842. And so part of me wonders, because there was this bond that the defendants had to put up to ensure that she was able to go through the legal process, she was safe in a certain way. So I wonder, did she live with them? I don't know exactly. And it would have been extremely awkward, maybe. But it's possible also that, I know in other cases, I don't know about this one, that enslaved litigants seeking their freedom lived or spent their time during the course of the lawsuit at the local jail for their own safety at times too. It wouldn't have been ideal, obviously, but that was one process. But at least for Julia, I unfortunately don't have any evidence on where she spent the time.
Marty, do you have anything from the Zoom watchers?
Well, one, it's a comment, which is from Catherine, says Julia did ask for damages. And with as much as that you've given us, it's hard to pin down a specific part. I think we're going to have to recommend everybody read your piece in the Arlington Historical Society magazine for some of this.
I couldn't agree more.
Yeah.
To read it in the magazine. Absolutely. Anybody else here in the audience? All right. Well, thank
I'm
you.
on Zoom, but I have a question.
Wait, one more.
I'm on Zoom, but I have a question. When Wesley sold Julia the day after his deposition, didn't the court or the clerk notice that the day before he said that she was to be free? I thought her original sale to him mentioned her status as well. So how could he argue the bill of sale and like negated that?
Sorry, I had a little bit of difficulty hearing, but I think what you're asking is why was he able to conflict his testimony the day before in a separate lawsuit? Why was he able to record and sell her despite his testimony the day before? Basically,
yes.
Yeah, that's a great question. I mean, there were two different issues. One was testimony, and in the Crump case, he was just a witness. He wasn't a litigant there. And so he was testifying under oath, but that was also in a case that was out of Florida, and that probably just wasn't known to Julia. I guess it wouldn't have really mattered in terms of having the bill of sale recorded and gone through all the legal processes in Fairfax County, and I don't think that would have ever been known. And as long as he was able to attest to that, I think as a bill of sale process, some deposition statement that he made in another state, even if it was the day before, wouldn't have carried it. Someone would have had to challenge it, and Julia wouldn't have known, and Austin wouldn't have minded. He wouldn't have challenged
right.
it.
Yeah. Okay. Thank you very much.
Oh, one more over here in the audience. 1 second.
Thanks. Did you do much? I'm sure. Did you, by chance? I'm playing Judge Cranch in a play. So
nice. Yeah.
So self-serving question. Did you do much research on the parties, on the lawyers and the judge? I was shocked just to learn yesterday Cranch was from Massachusetts.
Yeah, he was a really long time jurist. Appointed 1801. I want to say he was on the bench until the 1840s. He was there for a long time. The only one of I think he had jurisdiction over all of the federal cases. And federal courts then had a much more limited jurisdiction of the, I guess would have been the Alexandria division, and was only one of a handful of, I think, federal judges in the district court in DC. I did some research actually on the father and son duo, the Brents, the lawyers for Julia. I should have included a bit more, and I'd have to go off the top of my head here, but one of them was actually a congressman from Louisiana at some point, the father, and then the son became one of the first attorneys general of Maryland. Before that role existed, it was a different process. But in the 1840s or 1850s, the son, the younger Brent, became one of the first attorneys general of Maryland. But what's interesting is that the father and possibly the son were slave owners themselves, which I thought was striking. But yeah, the role of these lawyers during this whole process really is an interesting topic that I think is ripe for more research. I think also the one of the more famous lawyers who litigated these slave suits was Francis Scott Key in Maryland. Yeah, sorry, I don't know if that answered your question. I'm just sort of musing. But
how complicated all this is. You've got Julia being defended by a lawyer from Louisiana, represented a judge from Massachusetts in a DC trial, hovering between Virginia and
right,
law.
right.
Okay, well, thank you very much, Zach. Oh, we got one more from the head of MEA.
This is not a question. I just wanted everyone to know that there is going to be a dramatic representation of Julia's court case. It's going to happen 3 times. April 18th, I think it's on your sheet, at Central Library, the next weekend at the Ballsellers House. And we are going to dedicate a stumbling stone for Julia on May 2nd at 1 o'clock in front of Lubber Run Community Center. And we'd love everyone to be there as well. So thank you.
Thank you very much. All right. Thank you very much.
Thank you so much.